Today, we have a gentleman that I haven't seen for many, many years, but I've heard him speak, and he does an awesome job. His name is Tim Davis, and he's from Kansas City. He's an attorney with a law firm there, and he has practiced exclusively in the world of employment, labor law for a long time. I got the bio, and I promised him I wouldn't read the bio to you, so he can hit the highlights of that. Tim and I were both on the Missouri SHRM Council, and I was a governmental affairs representative for 3 years, and I think he either followed me or came before me. So all of you that have been to the state SHRM conferences have probably heard Tim speak before, and he does an awesome job. So please help me welcome. And Tim Davis, we'll go into that. Thank you, and have a great day.
Thank you, Randall. Appreciate it.
Thank you.
Good morning. I think this thing's working all right, so I feel like Justin Timberlake. Never had one of these before, so it's going to be an interesting morning doing this. Thanks for having me, Randall, and the Connell team. This is a great group and a great opportunity to speak with you. I understand we've got a mix here today of mostly SHRM type people, some business owners. Is that kind of what we're looking at? Good. Well, I'm going to try and speak to both here. And the three topics I'm going to cover today are: we're going to talk about what's happening, what's changing. And this is such a hard program to do because it literally changes overnight. I updated stuff. I've got a newer version of this that I updated in my hotel room last night that I didn't get this in here because I'd already sent it down. But things are changing literally overnight with on the federal level, on the state level, and all the things we're dealing with. So that's what we're going to cover first. And then a subset of that we're going to talk about is the Me Too movement, the Time's Up stuff, and what we need to do as business owners, as HR people, to make sure our cultures are prepared for what the world is evolving to in that regard. And then a subset of that is, how do we do effective investigations if we have issues with employment matters? And so these three are going to kind of stair-step down from a broader topic to a more narrow topic to an even more narrow topic in the 3 hours we have together. I'm going to get sick of hearing myself talk only, so if we're going along and you have questions, throw your hand up, somehow get my attention. I'm happy to take any questions you might have. If it's about a personal situation you're dealing with right now that is too long or too detailed, I'll stay around as long as we need to this afternoon or this morning, I guess. And we have to do hypothetical questions because I can't give you legal advice. So hypothetically, if something's going on, we're covered on that. So those are the basic ground rules. Okay, I got to turn this thing on, don't I? There we go. This is our firm. For those of you, I know all the SHRM people who've heard me talk or seen about our firm a little bit. We're a national law firm. My office is in Kansas City. We're the second largest office in our firm. We've got 21 lawyers up there. Atlanta is where our firm was started in 1946. We're the longest lasting or oldest labor and employment exclusively law firm in the country. All we do is labor and employment law. All we do is defense. I start with that because if you have questions about things that are going on in your place, don't think I'm going to say, man, that company is screwed up, I'm going to go sue them. All we do is defense. So all we would do is help you with your issues. We don't ever sue employers. We fight with employees that are suing employers, and we fight with labor unions, and we fight with OSHA, and we fight with all other governmental entities, but we don't sue companies. So that's who we are, a little bit about us. If you do want information about us, we do all kinds of free newsletters and things like that if you're not already signed up. I know a lot of the SHRM people probably already received those. But if you want to get information, we don't charge for these. We just send them directly, and we can get you that kind of stuff quickly. Last thing I'll say about us, just this year we were rated the #1 law firm in the country for female attorneys and the #1 law firm in the country for minority attorneys. We've got, as you might imagine, on some of our coast and down in Texas, we've got significant different minority businesses and stuff. So we are expanding to meet our clientele as much as we can, and that's been very beneficial to our clients and our firm. One last thing about me, I was the former president of, as Randall said, I was on the statewide committee, and I also was the president of SHRM KC, and we won the Pinnacle Award this year due to in Washington, D.C. because of the way we're doing things up in Kansas City. So very proud of that role and what we've accomplished. So let's get to it. Where do we go from here? Let me get a drink quick because it's going to get fast. It's been an interesting show so far. The way we see it as labor and employment lawyers, it's always going to be better. And I'm not going to talk politics on you folks here today. That's not what we're here for. But politics definitely impacts on labor and employment law, as you know, and for reasons you may or may not know that we'll cover here a little bit today. So we do have a Republican in place. And all the kind of weirdness, the kind of craziness that you're seeing coming out of D.C. isn't really turning into major issues or challenges for us as employment lawyers, with the exception of one area, which is the National Labor Relations Board. And that place went crazy in the last month. With some judges that were appointed to that board that should have recused themselves from some cases, didn't, ruled on a case, had to withdraw the case, all that stuff. But otherwise, in our world, a lot of what's happening on a federal level isn't really changing with the administration. And if it is changing, it's for the better. What is happening is, as a result of a Republican running the show in Washington, D.C., the states are going absolutely crazy. The states are passing all these new laws that are much more, I'd say, pro-employee, less pro-business. And this year at the National SHRM Conference, is anybody going, by the way, to Chicago this year? I'm doing one of those podcasts or Todd things, whatever they're called, from the thing on this area. We call it Californication of America, where any of you that are in multi-state operations, you're really going to be have to watching how the state laws are changing so dramatically. Give you two quick examples. Kansas City. We passed a city ordinance in Kansas City about 2 months ago. It goes into effect June 8th, that bans employers from asking criminal records on your applications. It's called Ban the Box. You HR people are very familiar with that. It's spreading all over the country. What Kansas City did was go one step further. And Kansas City said, not only are you banned from asking it pre-offer, you cannot take any criminal history into account when you're hiring somebody unless you jump through certain hoops. You have to evaluate the job, you have to evaluate the crime, you have to evaluate how recent the crime was and how many times it had been committed, and you've got to make sure that whatever the crime that person is convicted of somehow doesn't preclude them from doing whatever your job is. So it's much more of a detailed analysis, not just saying you can't ask about it up front, but now you got to evaluate whether you can even use somebody's criminal record in your background. That's on our doorstep in Kansas City. On our doorstep in Oklahoma, just across the state boundaries there, Oklahoma's got a public referendum in July coming up for the legalization of marijuana, medicinal and recreational. It goes one step further and also says if it's medicinal marijuana, you cannot ban them or terminate them from employment based on use of that marijuana, unless, again, you can somehow show they're in a safety-sensitive function, something like that, like any medicine might preclude them from doing. So right on our doorstep, you've got stuff going on down in Arkansas with medicinal marijuana, but they're not going as far as Oklahoma is. Right on our doorstep, you're getting very, very unique changes in the laws that you got to deal with in whatever jurisdiction you're in. We'll talk about the federal stuff first because there really isn't much exciting. Or isn't that kind of drama going on the federal level, but we've got 6 more months where we know a Republican, whatever laws possibly could get passed, can happen after we get through the midterms. Who knows? Maybe there'll be a change in control of the House, in which case we're going to be in gridlock for at least 2 more years and maybe 6, if that's the way it goes, and the feds are just going to devolve into nothing again. So let's get into some of the stuff that we're talking about. Here's the 3 things that we think have a decent shot of changing in the next 6 months. One's called the Workplace Flexibility Act. Anybody here public sector, governmental? You guys are familiar with flex time, where you don't have to pay overtime. You can give time and a half off instead of paying overtime. The Workplace Flexibility Act would do that for our private sector, and I'll cover that in a second. The other is the paid leave. How many knows that right now there is an incentive, a federal tax incentive that passed if you provide paid leave to your employees for family medical leave? It's awful. It's weak. I don't know anybody that's doing it because it sunsets in 2 years, and who's going to establish a paid leave program that you get a tax incentive for that in 2 years goes away and you no longer have that incentive, but it's available out there. And then the Trump immigration stuff that we're dealing with. Here's the Workplace Flexibility Act. Not going to spend a whole lot of time on it other than to say if you're interested in getting out of the old system that's been around since 1938 under the Fair Labor Standards Act of you have to pay overtime for people over 40. This might be an option for you. And if you're interested in recruitment and retention of millennials, this might be an option for you because they care about their time off more than money. But what this would allow you to do is say, okay, if I work 50 hours in a week, I'm not going to give you overtime for that. I'm going to establish a leave bank, and for those 10 hours of overtime you worked, I'm going to give you 15 hours off that you can use later that year. So that's effectively what it is. There's a few hoops you have to jump through. You have to actually have a written agreement with your employees. You do have to accrue it at 1.5 times for hours over 40. There's a requirement that you cash it out each year. So if somebody finishes their bank with 80 hours in it, you've got to cut them a check at the end of each calendar year. And then there's this thing that you can't force employees to do it if they don't want to. It's got to be voluntary. But I think the public sector would generally tell you they like it. It's a way to control budget if you can control work time. But private sector, it's something I've been hoping for since I've been practicing for 25 years. And I think we finally have a chance of that happening. I'm not going to spend any time on this because this is ridiculous, but this is what it is. This is the Senate incentive. This just passed as part of the tax reform bill. That's how new it is. It's part of the tax reform we saw. For every $100 you would spend on somebody for paid leave, you can have this credit of 12.5 to 25%, and that's based on how long you provide the leave. So there's a floating kind of schedule for it. The law expires in 2 years. I don't know anybody that's really going to do this, but if you were inclined and do have paid FML leave already, then maybe you can get a tax break for it. Talk to your accountant about it and see if you can maybe save some money. Are you going to move to this system because of this law? I doubt it. But if you already do it, save yourself some money. The other thing I'll say, anybody here federal government contractors, this is a slide I added last night, so this might not, or last week, this might not be in your thinking. But anybody do federal government business? Okay, then you probably are aware of this requirement that kicked in. If it's got to be a special kind of business, it's got to be a Davis-Bacon or Service Contract Act. Davis-Bacon means you're doing federal construction work, so you're building an army barracks or something like that. Service Contract Acts means you're providing a service directly to the government. You've contracted to provide the fueling of the jets at Warner Robins Air Force Base or something like that. It's not all contracts that subject you to Executive Order 11246. It's those two specialty kinds. By law, you have to provide this now, this paid sick leave. But that's all we'll cover on that. Trump immigration reform, as we call it. Trump likes his name on everything, so I'm going to put his name on everything as well. Dead. It's just not going to happen. It's just gone so crazy that the reason you remember there's a deadline of March 1st for getting this DACA thing fixed. Well, a federal judge just banned Trump's changes, put in an injunction. So now there's no clock. And whenever there's no clock holding Congress and the president responsible for doing something, nothing happens until we get to the end. So I don't anticipate anything other than a few things you've seen here. You've seen I think it might be the next slide. Mandatory E-Verify is coming. Does everybody E-Verify already, or does nobody E-Verify? E-Verify is fantastic. I mean, I don't know anybody that complains about it. It's not a foolproof way of making sure you don't have illegal employees, but it's pretty easy to do, and it helps you do that. That will be coming. I think that's going to be the law by the end of 2018. So any of you that don't, you might want to start studying up on what that means. The catch will be, right now they're contemplating requiring all people who haven't E-Verified to do that for all their existing employees over a period of time. So year one, you've got to have 25%. Year two, you've got to now be up to 75. And then at the end of 3 years, you'd have to have 100% of your employees E-Verified. So that's what they're kind of debating doing. The issue that you'll have with that is if you have a significantly part of your workforce that you're concerned might not get through E-Verify, you'd have to start planning for what happens if that occurs. So I do a lot of work in the meat processing industry, and they're very concerned about that requirement that they E-Verify past employees. They've had to E-Verify others for years. So think about that if that were to happen. Do some business planning on how you would deal with that if it does. Agencies. This is where the Trump administration has really done most of this stuff. President Obama, as President Trump may face soon, for many years at the end of his presidency, had a split Congress. He couldn't get anything through Congress, so he did everything by executive order. So all this stuff that you see, the EEO1 report, Everybody in this room, well, most of you, if you had more than 100 employees, were gearing up for the fact that you had to put payroll data into your EEO-1 reports. The others of you that are 50 to 100 employees were gearing up for the fact that now you had to even do EEO-1 reports when in the past you didn't. That all got stayed, and that looks like it's going to be going away permanently very shortly, where you're not going to have to worry about that. The gender identity issue, the sexual orientation issue has been bouncing all over the place. We had, under Obama, the EEOC decided that sexual orientation and gender status is a protected characteristic under Title VII, federal law. Under Trump now, Attorney General says no, it's not. EEOC still says it is. So the federal government, in the case that now is before the United States Supreme Court to decide that issue, one side of the federal government, the Attorney General's office, submitted a brief saying it should not be covered. Another side of the federal government, the EEOC, submitted a brief saying it should be covered. So the federal government does not even know if its own law covers these issues right now. It's upside down. So we're going to see. The Supreme Court's going to decide this stuff. They've got a gender identity issue case before them that they will be resolving very shortly. They've got a sexual orientation coming up from the 11th Circuit, which is Georgia. And we'll know for sure soon whether Southeast Missouri, Southern Missouri, we have to add as a protected characteristic under federal law. If it's not under federal law, as you'll see in a second, Missouri has said it's not covered by our law. Sexual orientation, gender status, not covered by Missouri state law. Kansas City, Missouri, it is covered by city ordinance. St. Louis, it is covered by city ordinance, but the rest of the state, it's not. So we'll see how this plays out on a federal level very soon. But right now they're fighting. Government overtime rule. How many of you are going through that whole adjustment of bumping everybody's salaries up? And we had to get all that in place, and then the court stopped it. That's dead. That's going, not coming back. What is happening is they're doing rulemaking on that again, and President Trump's group is going to completely change that rule, and they're going to stair-step it up. So it's not going to stay at 24,000. If you're going to want to take advantage of the white-collar exemptions, it's probably going to be 30,000 by the end of this year. So start thinking about that. It's a lot better than 47. So it'll be 30-ish. Year after that, it'll be 33. I think they're topping it out at like 38 is the latest I've heard from our DC office who tracks all this. So from a business planning standpoint, from an HR standpoint, you need to start thinking about, okay, we're going to have to ratchet those salaries up over the next 3 years, but it's not going to be all the way to 47, and it's not going to be overnight like that was planned to be. So that's the FLSA. The wage and hour interpretation rules, President Obama said we're no longer going to advise employers on what complies with the Fair Labor Standards Act and the Family Medical Leave Act. Trump said, yeah, we are. And so they reinstated that. The first set of advisory opinions under these two laws in 8 years were issued yesterday on some pretty important issues where the federal government says, here's how we're going to interpret this. And one of them, I literally got issued last night, so I haven't added. What do we do in the world where we're trying to accommodate people's health conditions and they say, okay, I'm pregnant, I need to take a 10-minute break every 2 hours? Well, 10-minute breaks are too short to become unpaid, right? Under the Fair Labor Standards Act, it's got to be at least 20. So what do we do as an employer if I've got an employee now that needs a break every 10 minutes, or 10 minutes for every 10 minutes for 2 hours? Well, they issued an opinion letter on whether those have to be compensable or not. I haven't read it. It hit my email last night. But in this world where HR professionals, for those of you who've known me for years, I do a lot of union work, but when I'm in my office, 90% of what I do is can we fire this person? Can't we fire this person? But a good part of that has become for me, how do we deal with this injured or ill or sick person? That is the hardest thing I think you as HR people have to grapple with, the dealing with injured and ill people stuff. This thing we're talking about here might give you another tool. Okay, we can accommodate that. We'll allow that, but you need to know we don't have to pay for it anymore. I hope is what it says. I don't know. It could be the reverse, in which case I'll have egg on my face. But that might be helpful to us now that we're getting this kind of advice, dealing with those very sticky situations, particularly since the UPS decision 2 years ago that said you got to accommodate pregnancy pretty much the same way you have to do disabilities under the ADA. So let's keep moving and talk about some of the stuff. We got Alex Acosta. He used to be an NLRB guy. I've met him. I know him. He's actually a good guy. He's running the Department of Labor now. There's some things they're doing. So some of the things that the Department of Labor just started is if you think you've got wage and hour non-compliance issues, you haven't been paying overtime appropriately, you've been having people wrongfully classified as exempt, they're starting this new program similar to what Bush 1 did, whereby you can say, okay, we were wrong, we were bad, here's what we want to do. We're going to go back and pay all the overtime we owe, but they're exempting you from the liquidated damages, which means you don't have to pay the double time. Right now, if you're found non-compliant under the Fair Labor Standards Act, you pay your wages you owe, and you pay a double amount in liquidated damages. And then you pay attorney's fees on top of that. So it's a program, kind of a amnesty program, where if you've got issues, you can step forward, self-report, and get it done. I remember back in Bush 1 era, I didn't have many employers that did this. And usually if we did it, it was because we knew somebody was getting ready to file a complaint, and we jumped on it before the complaint got filed and took the program away. But it's an option that just was announced about a month ago for any of you that are concerned about that. What's this one about? Oh, this is more detail on that one. There we go. The white collar override, I've told you a little bit about that, so we can skip over that slide. That's gonna go away in 2018. The other thing the Department of Labor is everybody using the new I-9s as of September of last year. So about 8 months ago, we got a new I-9. It really didn't change much. I mean, you really have to lay them side by side and find the exact word. Changed a little bit of the stuff on the C list is really what it did, significantly. But otherwise, it wasn't a big deal. Just make sure you're using the correct one going forward. That's the Department of Labor. Nothing exciting, which for those of you who know, that means there really hasn't been many changes under the FMLA. That's still a brutal statute for a lot of people, but the Department of Labor isn't doing anything with that one. EEOC, it gets a lot more interesting. And it's because of this guy, for better or worse. And I guess I'm a husband and I have 2 daughters, and I don't want to see my family grow up in a society where this kind of predator and that kind of animal can do things to people the way they do. But it is gonna. That's the better part. That's really it's triggering a lot of stuff. The difficult part is we as a law firm and you as employers are going to have to really deal with some of the issues that it's bringing up. And that's what we're going to spend our second hour talking about, by the way, this whole what we can do to strengthen our organizations and deal with this long-term and historical issues that we as society has. But this is really what triggered it and what we're dealing with. It's going to probably, I would bet, have the single biggest impact on your culture and changing or making sure you're doing the right thing going forward in 2018. So we're going to cover that in some detail, and I've got kind of like an 8 or 10 step program that I would advise people to do on that. So we're not going to spend much time on that. Quick statistics. Good news is charges are down. In Missouri, they are way down because we finally got the law back where it needed to be, and I'm going to talk a little bit about that because Missouri was rated the #1 judicial hellhole in 2017. I think there's some scientific analysis as to exactly what a hellhole is, but we were rated the #1 judicial hellhole in the country, worse than California, worse than Massachusetts, because of our employment laws. And as you all know, as of August of last year, that changed significantly. So we're way down even from what we're dealing with on a federal level. EEOC on the sexual harassment side is up slightly, as you can see on that. It's the Me Too movement that is impacting that. Some of the things that the EEOC has done as a result of that is we've got some new guidelines. The EEOC now is saying we don't want to be as much of an enforcement agency. We want to be a help. So if you call us and want us to come out and train and review your staff, we will do that for you. I still don't know anybody who's done it. And in fact, what's interesting, the program they developed to train employers and provide stuff on this is conflicting right now with the National Labor Relations Board. So now we still got 2 agencies where one agency is saying, here's what you do as part of their training, that another federal government agency says, but wait, that's against the rulings we've had. And what I'm specifically talking about is some of those labor board rulings that say you can't have a policy that says you've got to treat people nice and be respectful in the workplace. The labor board says those policies are illegal because people have the right to yell and scream at each other if they disagree about union things. So a broad, no, you got to treat people with respect is against the law. And now you've got the EEOC in their training. Literally, the thing says it's all about respect. And training on you got to have a polite, respectful workplace as a way to prevent harassment. Well, these two don't get along, and so they're trying to reconcile that. So that's available to you from the EEOC. This is what it was right there. Their materials. If you're interested in that, check out eeoc.gov, and they can provide it, and you will have the benefit. Is everybody from the government here, by the way? I always ask that question first because they don't like a lot about what I say. If they ever say we're from the government, we're here to help, if you can imagine a government bureaucrat coming and training your supervisors about discrimination, how animated and exciting that program's going to be. So you get what you pay for, I guess, if it's free. Some of the things we are getting, we did get President Obama, or President Trump, I got to keep that, signed an executive order for employers dealing with this issue of free speech and religious liberty. So this is something that is out there. It's mostly on employers dealing with their health care and religious issues related to providing certain types of benefits to, if you're a religious entity, individuals like not having things like birth control or abortion or that kind of thing on your health plans as mandated, which Obamacare did. So we've got some changes there that President Trump did by executive order that you want to check out or be aware of if you're in that category that wants to deal with that. We're getting a lot of changes on the joint employer issue. It's surprising to me how much I'm dealing with this issue right now. Two issues are coming up more and more: joint employers and independent contractors. The joint employer issue is the federal government under Obama called it the triangulation of the American workforce. And triangulation was a bad thing because it meant a business owner here could outsource all of its employment activities to a temp agency or a subcontractor over here who would then supervise the employees down here. And then this owner was completely insulated from anything that this employer did. So they wanted to eliminate and pull that triangle together and say, we're going to broaden the joint employment standard, and instead of it being the direction and control standard as to who's actually supervising and managing these employees, which has been the standard for decades, we're going to use an economic realities test and look to see who really is in control of this whole situation. And even if employer here or owner here is not employing them because this person over here is, the economic reality is they're the same. So anything this guy does with his employees, we're going to hold this guy responsible for equally if they're not following the law. So there's been this huge push for the last 8 years to do that. The courts haven't always jumped on board. In most recent decision, this is an example, they didn't do it. The court says, no, we're going to use the direct and control test that we're all familiar with as employers. And the temp agency did something wrong. Construction company didn't. Construction company set up the wall and did it right. They didn't hire and fire. They didn't discipline. They didn't supervise and interact. So the problem you've got is with the temp agency's employees. Construction company, it's not your problem. That was good. That was going to be gone, quite frankly. Again, I'm not going to be too political on you here. If Hillary had won, we'd be in an economic realities world. The utilization of temp agencies, how franchise systems work, how contracting out work and subcontracting work would be completely different. And for those of you who use temp agencies, the world would have been a different world for you. So that's one area where politics did directly intersect because the whole economic reality stuff is now dead. So that's where we are. One thing that EEOC is, as part of the Me Too movement, really, really drilling down on. There's two areas where we're seeing tremendous expansion, whether it's the feds doing it or whether it's state and local governments doing it, and that is harassment issues, primarily gender-based harassment in the workplace, but even more so compensation issues. We're getting, as a law firm, more and more Equal Pay Act claims than we've ever had with our clients. And in part, it's driven by this. That map shows up a lot better when you're looking at it as a printout, but this map just shows the wage disparity. Right now, a woman, on average, makes 80 cents on the dollar nationwide as compared to men. And then these different colors break it down. Missouri, where we are here, is we're in the 75 cents to 79 cents on the dollar as compared to men category. And this is becoming a bigger deal, and that's one of the things that spawned from the Me Too movement is how do we get gender comp equity in the workplace as well. So we are seeing both governmental agencies taking a harder look at this, and more importantly, them damn lawyers. We're seeing more lawyers filing lawsuits on everything. So it's really becoming more of an issue, and it's part based on what we just talked about. I talked about this already, so I'll move quickly over it. Sexual orientation is at the Supreme Court level. The Supreme Court's going to decide it. We had the 11th Circuit, which is down in Georgia, that said that sexual orientation is not covered by federal law. We had the 7th and the 2nd. The 2nd did it about 3 weeks ago, say it is covered. So sexual orientation is up at the Supreme Court. They'll decide that in 2019. We'll know whether that is covered or not. Gender status, we had the 6th Circuit say it's covered. The Harris case is now at the Supreme Court. We'll know whether gender identity is covered and protected by federal law. In Missouri, we had a case, it was at the end, I think it was September of last year, where the Missouri Human Rights Act, which applies both to public entity, public accommodations, school systems is what this is about, and a private employer. So the definition of what's covered is the same. But this is the case where a court of appeals, a single Missouri Court of Appeals, ruled in Blue Springs, Missouri, that gender identity is not protected. School, you do not need to set up a special bathroom. That's what this case was about. It was a bathroom case. That case is on appeal. The Missouri Supreme Court will decide whether or not that is covered by our law here in Missouri. If they rule it is covered, then we don't care what the feds do because it's covered under the state law. If they rule that it's not, then whatever the feds do is going to become important. So keep watch on that. These are all going to be happening over the next 6 months that we'll see all this stuff develop. This is old news, but the one issue that was left out of the UPS decision back in 2015 is the accommodation issue. For those of you who don't know what I'm talking about, for decades, in my entire practice, the question an employer would ask is, do we have to provide accommodations for an employee based on pregnancy under the Pregnancy Discrimination Act? And for decades we said it, the court said it, everybody said no. The Pregnancy Discrimination Act deals only with you having to provide the same amount of leave that you would provide to an employee based on pregnancy issues as you would provide based on other issues. So if a guy breaks his leg and has to be out for 6 weeks on that, and you grant him a leave of absence, well, you can't tell a pregnant female you won't give her 6 weeks of leave of absence for the pregnancy. That's how the law was applied. That's what we did with it. And we actually told employers you should not accommodate a pregnant employee more than you do a non-pregnant related issue, because now you're broadening it out where the reverse is true. Now you've got to give everybody else these longer accommodations, so don't do it. So the case got up in 2015, Young versus UPS, and the Supreme Court, contrary to what everybody believed, said, no, you guys have been doing this wrong. We've been enforcing this law wrong for the past 40 years. And this law does require you to provide reasonable accommodations to individuals based on pregnancy. So we've been, okay, fine. Don't have an issue with that from a societal matter, from a legal matter. I hate to say it, I don't think that's correct. I think it had been applied correctly for 40 years and they just told us to do it wrong. But anyway, from a legal matter, that's where it is. From a practical matter, that means, okay, pregnancy has to be treated the same way as ADA, basically, for the purposes of reasonable accommodations. I can only work 8 hours a day. You want me to work a 12-hour shift. Give me a reasonable accommodation. Let me take this time off. And then we fold in the FMLA, and that's what you HR folks are thinking. I can see it already. Well, isn't that intermittent leave? Yes, and we'd have to deal with all that. So yes. But right now we have to provide reasonable accommodations based on complications or issues related to a pregnancy, like we would do with the ADA. The one question that was left open out of this decision, and there was a little bit of dicta in the statement that says, you have to provide the same type of reasonable accommodation as you do under other leave policies and workers' comp. And that's where it got weird, because I'll bet you folks, when you're doing your workers' comp, do something special, and that is you create light duty to get people back to work. I'll bet the good folks at Connell tell you to get them back to work. So the Connell, or the folks here will tell you, you probably have a light duty program where sometimes they get them back to work so they're not adversely impacting your rating, all that stuff. You do that. And so it's special. You only do it for workers' comp. You don't do it for anything else. Well, the question was, if you do that for workers' comp, do you have to do that for a pregnant employee and create work, not something real, not light duty, but actually a created position for them to do while they need it for pregnancy? we've been telling our clients, you don't want to be the test case. You don't want to be that first lawsuit that decides that. Let somebody else do that, and we can see what these other courts say. Well, that is now happening. Just about a month ago, in a case down in North Carolina, the EEOC filed a lawsuit because this company said they had 2 CNAs that were pregnant. The restrictions were they couldn't lift, pull, or push. One of them was 50, one of them was 20 pounds. The employer said, if we're going to put somebody on light duty, a true light duty job, not just restricted duty where we take a few options away, but a true program where you just kind of sit, and in this case, they were just counting medication. It's a nursing home, where if somebody had a light duty for workers' comp, they'd have them count the medication. No work really at all. They said, okay, that is limited to work-related injuries. We're not going to do it for pregnancy. We're not going to do it for any other condition, other than workers' comp. And that was their program. So they said, you're going on a leave of absence. The 2 CNAs went on a leave of absence, ran out of leave, and got fired. So the employer said, EEOC says, you could have accommodated them possibly by giving them these devices and by reassigning work like you do for people on workers' comp. That is pending in court right now, and we will get our answer once and for all what you have to do with regard to pregnant employees as compared to workers' comp. That's the first case. There's another one right now pending in Walmart that's a nationwide class action, a very similar. Walmart had a program saying we won't provide light duty similar to workers' comp to our anybody, just workers' comp. They ended that program when UPS was passed because they didn't want to be the test case. Well, they got sued on a nationwide class action for people that had impacted before they made the change. So on the old policy, the new policy is fine, but their old one. So watch that one. That's going to be a big one that's going to interact with pregnancy discrimination and accommodations, how you do workers' comp. We'll have an answer for you by the end of this year. Right now, I personally tell my clients, I don't care for lawyers much. You don't want to be sued by a lawyer. So do your best now to possibly accommodate, and then we'll see how the cases change it over the next year. So that's what I've been telling my clients, case-by-case basis. Real quick, the ADEA, that law has been in place for 50 years now, the Age Discrimination and Employment Act, for those of you who aren't doing it. There's some pretty interesting statistics that are coming out of it. I keep thinking I'm blocking people, so I should just try to stay out of the way. That top statistic there is interesting. 1/3 out of workers are currently over 40. Today more than, or in 67, today more than half are over 40. By 2020, 25% of the workforce will be over 55. So 1 out of 4 of your employees, and maybe all of you are in there already. And then we see these interesting statistics as it's starting to grow. We are getting growth in the number of EEOC charges brought by individuals that are alleging age discrimination. It's becoming very much a societal issue. As a general rule, and all general rules are subject to exceptions. The older we get, the sicker we get, the more health care we need. So it's not just a matter of our employees are getting older, our costs are going to be going up as a result because we're going to be dealing with that. But that's some of the stuff coming out of the ADEA and the EEOC. That's all the fun stuff there. Any questions on that kind of Title VII discrimination type component? We're going to be talking a lot about that in our next hour. So if you've got some, let me know. NLRB. I spent most of my week down in Arkansas with a client. I guess by trade, I'm called a union buster. If you don't want a union, I make sure you don't get one, and if you've got one, I help you deal with it. So this is my law here that I spend a lot of my time. About 50% of what I do is that. The biggest political football that exists is the National Labor Relations Act, because the way it's set up is the sitting president gets to appoint a majority of the judges on the board, the 5-member board, from his or her party. So every time we have a presidential party change, we get a change in the NLRB and the law goes crazy. So as of yesterday, here's who we've got. We've got a 5-seat NLRB. Marvin Kaplan was the chairman. He just got replaced by John Ring. Yeah, there we go. Ring was just approved yesterday by the Senate. So we've got the full labor board now. It's in Republican control. We're getting a lot of changes that are going to happen. even if you're non-union, UHR people know all the garbage we've gone through for the last 5 years on that protected concerted activity and all the provisions in your handbooks that were illegal and all the way you had to do investigations and couldn't keep them confidential. All that stuff's changing right now, and it already really has. So that economic reality stuff that I talked about, the labor board, at least as it relates to the National Labor Relations Act, they already reversed that decision, said we're not doing the economic realities, we're going to the right to control test that was existed, and said temporary employees, if you set it up right, are not jointly employed by the using entity. They're just agency employees. That was, the law had changed on that in a case called Browning-Ferris. The protected concerted activity standard, which had made so many parts of your handbook not legal over the last 5 years, was reversed. I'll cover that in just a second. The micro units and elections reversed. The ambush elections, biggest career change for me. When I started practicing law in 1992, we had 10 weeks, 70 days to run a union election if a union asked to represent the employees. Clinton shortened it to 42, President Obama shortened it to 21, and the federal government is getting ready to move it back to 42. So this was awful for us. Within the week, we're going to be getting a decision on whether you can have arbitration agreements with your employees that prohibit them from filing class action lawsuits. Any of you do arbitration agreements with employees as opposed to letting them file a case in court? This issue itself, on a broader scope, is caught up in the Me Too movement issue, because if you look at a lot of how guys like Weinstein and I guess President Trump has dealt with issues involving harassment or discrimination in the past, they bind people up into a confidentiality agreement that has mandatory arbitration instead of being able to go to court. That's what the whole Stormy thing is about. That's what in the employment world is about. I love arbitration agreements as a defense lawyer for all the reasons that the Me Too movement and all that stuff hates them. You'd be stunned if you knew the number of high-level stuff and high-impact stuff never sees the light of day because of these types of agreements. As an employer counsel and you as employers, they are fantastic. The Supreme Court is deciding only whether or not you can include class action in those arbitration agreements, or does that violate the National Labor Relations Act somehow. I believe the Supreme Court will say it does not violate the National Labor Relations Act, which then means you can prohibit employees from entering into these big class action lawsuits against you. It's great if you can do it. At the same time, part of this Californication of America that we're dealing with, many states, as part of the Me Too movement, are banning confidentiality agreements as part of arbitration. So they're banning us from including in these things a statement or a mandatory that they be kept confidential, any issues related to the thing. So this is very much in flux if you've got people in other states. It's not going to happen in Missouri, but it's very much in flux around the country, so you're going to watch these arbitration agreements as we go forward. Not going to talk much about this because it's kind of down in the weeds. All you need to know is however you've been managing, either as an employer or are there temp agencies here today? Are there any of you folks with a temp agency? However you've been managing that relationship, to make sure that the temporary agency employees are not also your employees under the direction and right to control test. That is the test again. Make sure you're keeping that clean, and you won't have to be concerned under all these federal and state laws that you're found responsible for whatever the temp agency is doing with those employees. We're not going to deal with that economic realities world under any of these laws now. That first case I showed you was an EEOC case. The Highbrand case is an NLRB case. So the agencies are back online with the way things have been pre-Obama. The PCA thing, how many of you had to modify your policies or your materials based on a lot of, I mean, I tell you, I reviewed 100 handbooks in the last 5 years, and I would bet less than 5 of them were 100% legal because of this. And of those ones that weren't, they probably had 6 or 8 provisions. Their EEO policies were not legal. Their confidentiality in the workplace were not legal. Their social media and those policies were absolutely not legal. Many of them had no cameras or no private recordings in the workplace. Those were not legal. All kinds of stuff that were found not to be legal under the broader standard under the Obama case. And right now they just changed it back. This is about a month old is all, where Boeing had a ban. Boeing said, employees, you cannot bring personal recording devices, cameras, cell phones into the workplace and take pictures or videos of things. Boeing obviously had very significant interest with people not taking pictures of intellectual property and ways of doing things in high-tech areas. The National Labor Relations Board under President Obama said that's illegal. Employees under this law have the right to engage in concerted activity. Part of concerted activity is taking pictures of workplace issues that employees have the right under the law to bond together and talk about and act upon in a concerted fashion. So we are telling you, Boeing, you cannot prohibit cameras and pictures in your workplace. That has been the law. Many of you probably don't realize that has been the law for like almost 3 years now. That was just overturned about a month ago. And they abandoned the whole test that the Obama board developed, got rid of it, and now we've got a test that says we're going to look at every aspect of an employer's handbook. And if they've got a legitimate business reason for whatever the policy is, in the Boeing case, it was we want to protect confidential information and intellectual property. Even if it does have some impact on employees' right to engage in concerted activity, we're going to weigh those interests. And in the Boeing case, they said that is a core part of Boeing's business, being able to protect their significant intellectual property. That's going to outweigh the minor impact it has on employees being able to take pictures. Boeing, your rule stands. Other ones that I've seen is a lot of companies, Missouri, you may not know it, but if an employee wanted to bring their phone into the workplace and set it on record to record everything that happened in the workplace, that would not be against the law in Missouri. You could do that. We're a single consent state. And in a single consent state, one person has to consent to the recording, and that's the person who's recording, right? So in Missouri, your employees could be walking around recording you every minute of every day if you do not have a rule saying they cannot do that. The Labor Board said those rules were illegal. Now the Labor Board says they're not illegal. And a lot of employers do it just because you don't want the impact that would have on your culture if everybody thought they were running around recording everybody. So think about that issue, and now you've got more flexibility than you did. Here's what the board said. I'm not going to cover this. Again, we're broad here today. But they developed 3 categories. Those rules that the employers, hey, it is clear the employer's rule is so not designed and doesn't have an impact on protected concerted activity. We're going to put those in category 1. Others we're going to balance, and we're going to look at them in greater detail. One of them that they're talking about there is the social media policies. If you as an employer want to put things on your social media such as thou shalt not, here's one of the cases they specifically said they're going to look at, thou shalt not put company logos or company materials on your personal Facebook or other social media posts. The NLRB said that's illegal. You cannot ban them from doing that. If they want to put your company logo or trademark as part of their complaining about this company doesn't pay fair wages, then they can do that. These guys said, well, we're going to relook at that. We don't think that's right. So if your social media policy has those kind of restrictions, they're back in the game a little bit. I'm not saying they're going to be get out of jail free card like they'd be a category 1, but you got to be balancing your legitimate interests. What I've seen in most of the ones when I review them is things that say thou shalt not say anything negative or derogatory about the company or our customers, vendors, or suppliers. That would be illegal even under this test. So if yours still says that kind of broad stuff, you got to take a look at that. And then the other category are those that are automatically and always have been unlawful. And that deals with things like employees may not discuss wages amongst themselves. That's been illegal since 1938 when this law was passed. Employees have the legal right to talk to their coworkers about wages. What was your increase this year? What was yours? How much are you paid? What do they pay you per hour? What do you pay for insurance? That's protected by federal law. They've always had the right to do that. But I still, to this day, come across handbooks that ban that have been reviewed by employment lawyers, and they didn't know that this unique area of the law applied. So that's what we're dealing with there. Here's the kind of stuff we're dealing with. This is an example of some of the stuff that has been found to be illegal in recent years. AT&T had a policy that employees may not record telephone or other conversations with third parties. The Labor Board said, well, what if they're wanting to record what's going on in the workplace to prove the company's not treating fairly so they can change that? You can't have that banning. ALJ ruled this was broad and said that policy is illegal. I think under the new policy that we just went over, that policy would be legal. So that's one of the changes. In the non-handbook, and PCA, by the way, stands for Protected Concerted Activity, for those of you who aren't labor law wonks. That means under the federal law, employees have the right to engage in union activity or other concerted activity with their coworkers to change workplace issues. That's where all this comes from. So this is actually a case, and this is one that the labor board just opined in this decision that they would say they would go the other direction. But this employee went on break. While he was sitting on break at a picnic table outside of his place of employment, he wasn't real happy. He puts this up on his Facebook that says supervisor is a nasty, and apparently he didn't care for the supervisor's mother either, or the family. And the employee is not particularly smart. Supervisor was a friend of his on Facebook. Walked back in the door, and within minutes was fired. Labor board said, well, wait a minute. Yes, he ranted a little bit and shouldn't have said that. But he was talking about bringing in a union, and that's protected. So we think the real reason you fired him is this, and we're going to make you give him his job back. So this guy got his job back after saying that. Could you imagine that in your workplace? Well, the labor board said this is one of the decisions they said we would, under our new test, would have gone the other way. So that's a good one. This is my favorite one. When we talk about this PCA stuff, Jimmy John's up in Minneapolis had a policy that they don't give employees sick time. So the employees were unhappy about the fact that they did not get sick days off from work. And so on their actual day off from work, a group of them started standing in front of the restaurant holding this sign. Just standing there with a sign, so as every customer walked by, they would have to read, "You're about to take the sandwich test." And as you might imagine, Jimmy John's didn't care for that and fired some of these employees. And the labor board had to rule, okay, were they engaged in protected concerted activity? Clearly they're acting in concert. Clearly they're acting about workplace issues because they're trying to get sick time. So it is concerted activity. But is the way they engaged in it so outside the allowable boundaries that it's not protected concerted activity? And the labor board in this case said, yeah, that's too grossly disloyal. To right in front of the customer say you're about to take the sandwich test with a bunch of sick employees making your food. So how is that not protected and this is protected? That's the weird standards we were having under the Obama labor board, where it's hard for me as a labor lawyer to guide my clients and say, I would have said fire this guy. If this was my client, I would have said that's way outside. That's so grossly disloyal, you're going to meet the test, fire him. This one I would have said is protected. So the world's upside down. Under both of these, under the new standards, they would not be protected, so we got a lot more flexibility. So here's some other stuff that's coming. I'm not going to deal with this, all of it, but read this in the materials when you get it. If you've got handbook and policy issues, pay close attention to this protected concerted activity stuff we're talking about today, because it's going to have an impact on the legality of your handbooks, far more than any of the other stuff we're going to talk about. So these are all the things that are coming down the pipeline. Rob is that general counsel who I mentioned earlier. He laid out in an advice memoranda, here's all the stuff that Obama board did that I don't like, and we're going to change it as soon as we can. And it's going to give us a roadmap to how we then, okay, these policies are going to be fine, these policies are going to be fine, and we can look at stuff and change or get your policies and procedures, manuals back to where you would want them to be. So some of the big ones. Email system, you may not know it, but under Obama, a case called Purple Communications, the labor board ruled that you have to allow employees to let them use your email systems if they want to talk and organize a union. Never before had that been allowed, but that's a decision that's going to be overruled. So a lot of good stuff in this memoranda to keep in touch with. So we'll move outside the labor board arena now and start winding things down. The biggest impact any president's ever going to have, most people don't realize it, at least in the employment world, is judges. President Trump will appoint more judges than any other president in history. So the federal bench is going to shift dramatically in his tenure. And the main reason for that is because the Senate would not approve any of President Obama's for the last 2 years of his presidency. So we got this whole backlog, and then we got the normal turnover. In that, he's already approved Gorsuch as one. President Trump will probably appoint another one and probably 2 Supreme Court justices. So the whole Supreme Court is going to change. And there are literally hundreds and hundreds of out there. So from an employment law standpoint, in general, when you get a Republican president, the laws get interpreted much more favorably for us. So we can expect to see, oops, that was clearly the wrong button, a big change in that. These are the cases that are up there in front of them right now. The Horton case involved that arbitration. I already talked about that. Sexual orientation are both up there. And then we got a kind of a wonkish one on the DuPont case on whether or not if you give employees paid breaks, you can offset that time for if making them come in earlier or later. So that'll be one to watch as well. It might impact on your comp practices. I'm not going to talk a whole lot about these series of cases here, other than, as I said earlier, one of the biggest challenges that HR professionals and folks like me who guide them are this whole time off issue. And one of the difficult ones has been, well, what do we do? Employee went out on a leave of absence. Our policies provide 8 weeks if we're not covered by FMLA, let's say, or a small employer, and 12 weeks if it's FMLA. And this employee's used whatever your policy or the law requires. And now they say I need to take 2 more months as I'm recovering from my condition. Do we have to provide that as a reasonable accommodation under the ADA? And there's still no absolute cookie cutter answer to that. There's guidance and there's narrowing the requirements. And some of these courts are now saying a multi-month leave beyond the scope of the FMLA is not reasonable. This law was designed to allow people to be able to work, not to give them a lengthy leave beyond whatever other federal law said. So we're getting more and more parameters on when you have to provide additional leave as an accommodation. What I tell people is get advice from your doctor. Find out specifically when that person would be able to come back. If it's not a predictable time they can tell you to come back, the courts are saying it's unreasonable to require an employer to hold a position indefinitely. So you're in good shape there. If it is a time that you get, how long is it? Is it a week? It's probably a reasonable accommodation to give somebody 1 extra week of leave. Is it a month? Now we're starting to talk. In Kansas, the Kansas State case I didn't put up there, they fired a professor who was recovering from cancer. And the professor said, I'll be able to come back in a year. They said, that's too long to hold your job, replaced him, he sued. The court said, as a matter of law, 1 year is way too long. We're not going to find that to be a violation. So look at what the diagnosis says, how long it is, and then the third factor you're supposed to look at is, what are you doing in the interim? And the case that I've dealt with involved a bank, and a teller had to be out for 2 additional months beyond her FMLA due to complications from her pregnancy. This bank is a large bank. They're in every state in the country. And they've got teller pools. So if somebody is absent from one day, they just route somebody, kind of like a hospital float pool. They route somebody from the pool over and they're covered. So they were going to no additional costs, having no additional impact on the business to grant this teller 2 more months off leave. Was it a reasonable accommodation? Yeah, it was. Their business was unique in that respect. Yours might not be. So look at what the doctor says, look how long it is, and look at how you cover it, costs, disruptions, whatever it might be, and see if it's reasonable for your business. That's the guidance we're getting now, combined with some of these cases that are much more pro-employer than what we've had in the past. I love talking about marijuana. It's a big issue these days. We've got, I think, 29 states now that have legalized at least medicinal marijuana. We've got many others that are doing, I think there's 10 now that do recreational. Arkansas is joining that group. Oklahoma, as I mentioned earlier, is joining that group. I believe Missouri will probably have medicinal marijuana legal within the next year or two. I wouldn't be surprised if all states have legalized medicinal, and more will then legalize recreational. So what's that mean to us as employers? In most jurisdictions, what that means is we can still do all of our drug testing, we can still do everything we want to do and say you cannot use it. We don't care if the law says you can use it for medicinal purposes, we're not going to have employees on marijuana in our workplace. And almost all jurisdictions are saying employers do not have to change their policies and procedures one bit on this. It's not going to impact you. But it is a state and local law driven issue. The feds still say it's illegal, so they're out of this game. It's a state and local issue. So we're getting states that are starting to come down opposite of what I just told you. And some of the states, Massachusetts and Connecticut, have now said if somebody is on medicinal marijuana due to a disability, a possible reasonable accommodation might be not holding them to the same standard under your drug testing policies. So in this case, we had a guy who failed a drug test, marijuana, said, hey, I can prove it. My doctor's prescribed it. I'm on it for these reasons. The company said, we don't care. You're fired. And the judge said, not under Massachusetts state law. You can't fire them for that now. You've got to do more of an analysis. Is there safety-sensitive functions? All the kind of stuff you would do that might mean you don't have somebody that uses this. Connecticut just jumped on board. That might be my next slide. Yeah, Connecticut just did the same thing 2 weeks ago. Oklahoma, for those of you who might, that's our closest state, is getting ready to do something very similar. I think that referendum is going to pass in Oklahoma in July, and then Oklahoma is going to have if you do drug testing or you have employees over there, you're going to have to do it differently in Oklahoma. If you've got employees in California, Washington, or Oregon, you're probably going to have to do it differently. Colorado came down opposite, by the way. Colorado said, regardless of what our law says, you can still run your drug testing policies. The point of it is, everybody's getting on board this thing, and you're going to have to monitor all the different jurisdictions you practice in to see how this and similar issues change. So that's marijuana. Oh, there's my statistic. That changed. We've got 31 now, I think, not 30. 8 with recreational, and that's where we stand. So real quickly, I'm going to do some quick state law updates, and then I think we'll wrap it up and take our break. This is the law I was talking about before, why Missouri was rated a judicial hellhole. We had 3 cases in the winter of 2016, right before Christmas, where one in St. Louis, 2 in Kansas City, where in single employment plaintiff cases, you discriminated against me because of my gender. One was religion, one was, I don't remember what the third one was. One verdict in St. Louis was $16 million. We had one in Kansas City that was $20 million and one that was $10 million. Single plaintiff, not collective actions, single individuals claiming discrimination. And that's what the jury awarded in those cases. And it's because Missouri did not have, which I'm on the wrong slide. Missouri right to work, let me go back to that. Get out the vote on that, folks, coming up real soon. Missouri is going to a public referendum on whether or not we become a right to work state. That vote is coming in as part of our midterms, and that vote will decide whether Missouri is right to work, which means employees don't have to join a union if they don't want to, or we remain where we are, which is a union shop state. All the other states are going this direction. Missouri would be left behind, so that's my 2 cents worth on that. But here's the stuff I was talking about with some of these verdicts. We actually tried one. We had a trial in March coming on the heels of these 2 verdicts. And the demand that we got in that trial was, the last settlement demand from that plaintiff was $3.6 million. They would only take $3.6 million to settle the case. It's a terrible case. There was no facts to support the person. Our client was brave, because when you just saw this happen a few months before, to stare down the possibility that you could get a hit with unlimited punitive damages, I give them a lot of credit. We tried the case. We won. There was no verdict at all. They ruled for our client. But that's the stakes that you as employers had to deal with. And we've done trials in South Missouri, in Joplin and in Springfield, where we were dealing with this issue, where even in the less big city type places, the juries could have awarded these unlimited punitive damages. And it's kind of scary when you're walking in there knowing that that group of people can put you out of business with a verdict that high. That's what the law was. That's why we were a hellhole. Well, Greitens did sign the law. He put caps on damages. Now the cap on damages, $300,000. Not unlimited, not crazy stuff. We have rejoined the world of the living, and we don't have that crazy stuff. That kicked in August of last year. So many people who had never faced this kind of existential threat based on these cases now realize we've got caps. Even more importantly, the test under Missouri law before the law change was called the contributing factor test. And imagine everyone, if you're sitting on a jury and the plaintiff's lawyer concludes by saying, I've got a sheet of paper right up here for all of you to look at. That employer could write 1,000 reasons on that sheet of paper why my client should have been terminated. Poor performance, didn't come to work. All of these totally legitimate reasons why my client got terminated. But if one of those reasons on there is that they did not like the fact my client In the one case, wore a headscarf because she was Muslim. If that is even one of the reasons on there, you got to rule for me. You got to rule for my client because that's a contributing factor to your decision. And under that standard, which was incredibly broad, and unlimited punitive damages, and the fact that they could sue a supervisor, manager, or owner individually, not just the business, Missouri was a judicial hellhole. All that changed. Now it's the motivating factor. You've got to prove to that jury that the reason you were terminated is that protected characteristic, not that it was just one factor. You can no longer sue a supervisor or HR person individually. That's eliminated from the Missouri law. Back in the day, all of you could have been sued. And now we've got damage caps. So Greitens has got his own personal struggles going on right now, but he made all of our lives a lot better as business owners last year. And here's the kind of stuff that I said 300, it's 500, 300 is a federal law. Here's the kind of stuff that your caps on back pay and attorney's fees would be now, and all the stuff depending on the size of your business under the new Missouri law. So many of you have EPLI as a backstop for this kind of stuff, but now your world just got a lot better. And that's all. This is whistleblower stuff. I won't cover that in here today. What I would say on this stuff, by the way, I still think with the Me Too movement, everything else going on, now is the time to update, refresh, get your policies in place, and do training. One of the big things that it's shocking to me, Harvey Weinstein has been great for my business, I have to admit it. I've done more harassment, discrimination, policy review, and training in the last year than I did in the last probably 10, because you need to do it, but it's been a big thing. But these are the kind of things you should be doing now. Even though our state laws are better, that doesn't mean that you shouldn't be trying to do, and we're going to cover that a lot. Social media. I started training on social media as part of my harassment discrimination because I found that a lot of the really stupid things people used to just do in the workplace, they can now do about the workplace online. I had a case recently in Washington, Seattle, Washington, where a guy was enamored with a coworker, and so he would go into the bathroom and take pictures of himself and text it to her while at work. I'm sure you ladies could really appreciate you're sitting working and you get that kind of picture pop up on your, well, for some reason he thought she would like it and she didn't. And he posted stuff on social media, all kinds of stuff. So incorporate that stuff into your training when you're doing EO training. Supervisors are supervisors on social media, whether they're at work or not. And I had a supervisor post stuff up there of himself wearing, it might be the next slide. It's going to be coming up, so I won't talk about it. Stupid stuff that at Halloween that showed him simulating the beheading of a guy dressed up as a Muslim. And that was his Halloween costume. And, well, what do you think the Muslim employees thought about that when they came to work? Supervisor is a supervisor, whether you're at work or not, is my opinion. And employees, if they do stuff that violates our EEO and harassment policies, we got to deal with that at work too. So that's why I talk about that. Trends to watch. For those of you that are multi-state employers, as I said, I'm doing a whole program on this in Chicago this year. Paid sick leave. All over the country, we're getting mandatory paid sick leave policies. Austin, Texas, of all places, Texas just has a mandatory paid sick leave. Minimum wages, dramatically different. Applications, two things on applications. Ban the box, which means we can't ask the background check, is sweeping America. KC, St. Louis in our state. Ban the pay talk is sweeping America. We don't have that in our state yet. Ban the pay talk means you cannot ask people their current salary or wages until you've given them an offer of employment, and then you can discuss that. The idea being, the reason women are getting locked into lower wages and minorities are getting locked into lower wages is they come in with lower wages. And they say, I'm currently paid $30,000 a year, and you as a great employer say, okay, we'll pay you 32. And now they're at 32, but men in similar category that come in at 36, and you say, we'll pay you 38. Well, you've locked in that disparity. So these laws are banning the discussion of compensation for that reason. I have a pretty good feeling that depending on how the midterms go, we could see that as a federal law where you cannot ask compensation issues before you hire. Marijuana, big deal. Sexual orientation and gender, we've talked a lot about that. Here's the stuff I mean about ban the box. We now have it in Kansas City, Jefferson City, and I believe St. Louis have passed ban the box ordinances already. So if you're recruiting up there or you got offices up there in any of those three cities, and you take your application up there as part of a job fair, or you do something like that, and it's got asking somebody about their criminal background record on it, it's illegal. Your application itself is illegal. In Kansas City, that isn't until June 8, by the way. In Jeff City, it's already the law, and St. Louis, it's already the law, I believe. So keep an eye on that as you're going around to different places. You're also going to have the Fair Credit Reporting Act backstop. By the way, ban the box does not mean you ultimately cannot put people through a background check or that you cannot ask them about criminal records. You just got to do it after you give them a contingent offer of employment. So your application would be what it is. You wouldn't talk about criminal background. You'd just say, okay, here's your offer of employment. It's going to be contingent upon you passing a background check that satisfies our requirements. And then you put them through the normal Fair Credit Reporting Act background check, and you could still refuse to hire them in most places. I told you already about the screwy thing that Kansas City did, but that's how it works. It's not that you can't do it, you just got to time it out different. I thought I saw a hand over there. The question was, did I state it correctly? Is it Jeff City or Columbia that has the ban the box? And the lady's correct, it is Columbia, not Jeff City. The lady's question was, if you're in a certain industry, like I know what you're talking about, the healthcare industry, where you've got to have certain limits based on like your contracts and stuff, saying you've got to do a background check. Should you make a note on your application saying you will be required to complete a background check and all of that? Short answer is everybody could do that. So on your application, you could say all employees will be required to do a background check as part of the hiring process. You can still have that language in there. And in healthcare, certain parts of healthcare and banking, there's also a special exception saying if you're required by another state law or federal law or other law to do a background, to ask, you could still do it. So there's exceptions, even in Kansas City, to that rule for certain industries and types of jobs. Again, this is why multi-state employers, that's what Kansas City says. St. Louis is different. You're going to be running into a checkerboard all over the country of what the different states say you can and cannot do if you're a multi-state or multi-jurisdiction employer. It's just going to get that much harder. So, great questions. So that's Kansas City. And the pay talk is going to be the similar. Every day I get notice of a new city predominantly, because cities move faster than states, and states move faster than the feds, banning this pay discussion, where you cannot ask people compensation issues pre-offer. So none in Missouri right now that we're dealing with, but keep an eye out for that. And if you're in a multi-state jurisdiction, be prepared that if anywhere you're going to do an offer or an interview or anywhere you're going to hire employees, you need to talk to somebody about what our state says. Identity theft is becoming a big issue. I'm almost done, so we'll take our quick break. We had this situation come up in California. This is not a case we handled, but we as a law firm have gone through hours of mandatory training on protection of our computer systems. Because these scams, in this case it was a phishing scam, where an employee posed as the CEO. There's a way they can do it where it looks like the email's coming internally, coming from one of your trusted people, and it's phishing, and sometimes it's called spear phishing or whale phishing. From the CEO, it's called whale phishing because the biggest whale is the one that sends it, I guess. And so ask for the employee's W-2 forms. One employee out of the entire place said, okay, here's my W-2s. They didn't want the W-2s, that was irrelevant. Replying to that email then allowed the spear phisher to access into the system and then stole the data of 10,000 employees. The employees filed an action and they won a $6 million settlement because the company had not done what they should have been doing to protect data, including training employees on how to deal with potential things like this spear phishing stuff. So that's becoming more of an issue. That's a California case. That's the first one I've seen like this. This just happened last week, by the way. That's why I put this on there. Or not last week, three months ago. So be aware of that. You do need to do something to make sure your systems are protected if your systems maintain private and confidential information about your employees. Social security numbers, other stuff where their identity can be stolen. So be aware that's a growing area of legal concern. And then this one is awesome. This isn't America, but I just read about this the other day, so I'll conclude and take our break with this one. This company called Three Square Market had a party where if employees wanted, rather than having to carry a badge and having to do anything with regard to employment, the company could insert a microchip into your hand. And so every day you just wave your hand under the thing to report into work. If you wanted to buy something at the commissary, you just stuck your hand under there. Your entire thing related to your work, signing up for benefits, all you wanted to do, you could just do it with a hand swipe. And personally, I would do it. I don't care. I would probably do something like that. But that's coming in the future, where we do all these things as a law firm all the time on what our clients can or shouldn't do. And obviously you saw from this slide how the laws start interacting with privacy. But biosecurity is probably going to be the only thing that's going to ultimately fool all of these people, whether it's some sort of special microchip or your retina or whatever. That is the wave of the future. And our kids will not even know what a time clock is. Our kids will walk into a building, and the building will know where they are at all times. It's becoming part of security, so you know where everybody is from a workplace security standpoint. It's becoming part of the payroll system. This is funny to talk about, but 10 years from now, I'll be surprised if a lot of people aren't doing this very, very thing once it's been perfected. So that's our legal update. We're gonna finish the day after your break talking about the Me Too effect and how to conduct effective investigations in this new world that we're in, and then wrap it up.